Sub copy.
Item 127.
127.
127. Yes.
That was released at serial number 186. We have final IN number 580 of 24. The opposite button of 1 and 2 is going to disperse the compensation amount.
No. Give the
resolution.
item serial number लिख दीजिए. नहीं लिखी चीज़ ऊपर है.
I may be pardoned, lordships.
All right.
Yes, admission, madam.
Madam, this is item 183. Taken up next week, any date, madam.
They are in the list. We are not taking it.
No, it's last day we should not reach, madam. Already.
We are not taking it out. It is there in the list. Yes.
Item principle of the weekly list, madam. This examination matter of the judicial examination matter, madam. It will become there is a possibility of the time the matter is not able to reach, madam. So that next week any supplement list, madam.
Next week.
And okay, madam.
Pardon to make a mention, your lordship. I may be pardoned to make a mention, your lordship.
Yes.
Read petition, your lordship. Maybe pardon that I'm mentioning the diary number. The objections have been complied with. I'll get the number in the first half itself. The diary number 39736 of 2024, your lordship. It's a matter assigned to the division bench of Justice Das, your lordship, with regards to endowment matter. The urgency involved in the matter is that, your lordship, if this honorable court does not hear the writ petition,
please give the writ petition number.
Yes, your lordship.
Yes.
My associate will be.
Item number 3. Yes.
Supplemental list, item number 3.
Who has been engaged? Father, I have not. So, Choker's affidavit has been.
I have tried my best to prepare it. I made a query from the contemner, so also from his wife, that from where he collected that certificate. His wife is unable to give my answers to my query. She could not able to follow what I am saying. For that reason, I have requested him to come with a person who can explain all these things. She stated that his father.
No. She doesn't follow Odia language.
କହିପାରୁନି ମାନେ ମୁଁ ଗୋଟେ କଣ କହିଲା ବେଳକୁ ମତେ ଅନଉଛି ଯେମିତି କିଛି ବୁଝିପାରୁନି
ଆପଣ କହିଲା ଭର୍ଚୁଆଲ ଇଣ୍ଟରାକ୍ସନ କରିବାକୁ ସ୍କୋପ ଦେବେ ବୋଲି କିଛି ଅସୁବିଧା ନାହିଁ ଆସାରେ କଥା ହେଇଥିଲେ
first 2 minutes he stated that I have
whatever it may be, unless you file the so-called affidavit, how can we take
it? Just one session I interact with today in the legal aid.
He has come, you are free to interact, there is no problem. But prepare it expeditiously. Whatever you want to say, you say. ଆପଣଙ୍କର ଓକିଲ ମୁଁ ଜାଣିଲେଣି ସେ ବାବୁ ଆପଣଙ୍କ ପାଇଁ ଓକିଲ ଯୋଉ ନିଯୁକ୍ତି କରିଛନ୍ତି ହାଇକୋର୍ଟର ଯୋଉ ଲିଗାଲ ସର୍ଭିସେସ୍ କମିଟି ଅଛି ଆପଣଙ୍କର ଫ୍ରିରେ ଆପଣଙ୍କର କେସ୍ କରିବା ପାଇଁ ତେଣୁ ବାବୁ ଯାହା ପଚାରିବେ ଯୋଉ ଇନଫର୍ମେସନ ତାକୁ ଆପଣ ଦେଲେ ଯାଇକିନି ସେ ଜବାବଟା ତିଆରି କରିକିନି ଦାଖଲ କରିବେ ଆପଣଙ୍କର ସତ୍ୟପାଠ ହେଇକିନି ସେ ଜବାବ ଦାଖଲ ହବ ତେଣୁ ଆଜି ଆପଣ ଆସିଛନ୍ତି ତେଣୁ ବାବୁଙ୍କ ସାଙ୍ଗରେ ବସିକିନି ତାଙ୍କୁ ସେ ଜବାବ ତିଆରି କରନ୍ତୁ ତାକୁ ଟାଇପ କରନ୍ତୁ ଟାଇପ କରିକିନି ଇମିଡିଏଟଲି ଫାଇଲ କରନ୍ତୁ ହେଲା ତ ସେଟା କଣ ଦେ ତ ଏବେ ରଖିବା so we are taking out on 24th.
One thing I may be permit allowed to I want to record his conversation with me. Can it be allowed to me?
That he will file affidavit. Why will record the statement? whatever he will say, so you file by way of an affidavit and taking into account this provision of the contempt of why it has all the order sheet have been so the so-called affidavit is to be filed and you have to put the questions as you have rightly put some questions, but if he is not following, just try to uh, in Odia ask him and he whatever he will say just and after preparation of the affidavit obviously you are supposed to read over and explain what you have mentioned and then he will file the put his signature and oath commissioner is there he can be done during course of the day
in course of the day I'll prepare it and he will sign it and
obviously he has come for this ଆଜି ବାବୁଙ୍କ ଆପଣ ମାନେ ତାଙ୍କୁ ରହିବେ ସେ ଓକିଲ ବାବୁ ତାଙ୍କୁ ପଚରା ପଚରି କରିବେ ଯୋଉ ଜବାବ ଦାଖଲ କରିବା ପାଇଁ ସବୁ ତାଙ୍କଠୁ ଯାହା ଦରକାର ସେ ପାଇଲା ପରେ ସେ ଟାଇପ କରିବେ ଟାଇପ କଲା ପରେ ସେଟା ପଢି ଶୁଣିଲା ପରେ ସେଟା ସତ୍ୟପାଠ ହବ ହାଇକୋର୍ଟର ଯୋଉ ଓଥ କମିଶନର ଅଛନ୍ତି ତାଙ୍କ ପାଖରେ ବା ନୋଟାରୀ ଏଫିଡେଭିଟ ହବ ଓଥ କମିଶନର ଇଟ୍ ଉଡ୍ ବି ବେଟର ତେଣୁ ହେଲା ପରେ ସେଟାକୁ ଦାଖଲ କରିବେ ତାର ଗୋଟେ କପି ସମସ୍ତଙ୍କୁ ଦିଆଯିବ ଆପଣଙ୍କ ସରକାରୀ ଓକିଲ ଗୋଟେ ପାଇବେ ସେ ଯୋଉ ଆଡଭୋକେଟ ସମସ୍ତଙ୍କୁ ଗୋଟେ ଗୋଟେ କପି ଦେବେ 24 ତାରିଖ ଦିନ ମ୍ୟାଟର ଆସିବ ହେଲା ତାଙ୍କର ଲେଟରଟା କୁଆଡେ ଗଲା ଯୋଉ that is not the letter the legal aid acha previous order ta dekhiye as per the order dated 12/9/2024 Mr. Nityananda Panda advocate Mr. Dhanardan Sethi advocates club are present Mr. Gonia Gagarai is also produced from jail custody by swan so apanakara na ta debe apanakara number please give it as per the order dated 12/9/2024 the High Court legal letter the High Court Legal Services Committee has appointed Mr. Vikas Chandra Farija, advocate of this court, for this Gania Gograi to argue the case on his behalf. Mr. Farija is present and is submitted that he will have interaction with Gania Gograi in course of the day and prepare the sofas and after the affidavit is made, it will be filed, serving copy on the Land Council for the state. Also, the advocate previous order Mr. Nityananda Panda advocate, Mr. Dhanardan Sethi advocate's law put up this matter on 24th September 2024. On that day, till next date, Gania Gograi we detain in jail custody and he shall be produced before this court on the next date. This matter will be taken up at 10:30 a.m. Free copy of the today's order be handed over to the all concerned. Mr. Vikas Chandra Farija files the Bhinama which is taken on record. Ajitaro ye koronto for preparation. And this Mr. Nityananda Panda advocate, Mr. Dhanardan Sethi shall also remain present on the next day. Hello? Person.
Item number 1.
Yes.
My lord, I have challenged the notice that 30/2024 issued for vacation, handed over peaceful vacation, vacant possession of my residential house issued by the bank. Admittedly, I availed a loan in the year 2022. Loan was obtained to the amount
13 for notice you have challenged.
attended from notice. It has been challenged before the BIT.
Yes.
But there is some delay. But I have filed an application for combination of the delay. Notice has been issued, bank has appeared. But the matter has not been taken up on urgent basis. Though an urgent application was filed, but it has not been taken on now. The date has been fixed to 16/10. In this time,
File an advance petition in that respect. And when the matter, the alternative remedy you have already availed,
is that I have stated in my petition.
and this decision which you have referred to,
Yes, sir.
this
This annual report.
Selir, no, that is Selir LLP, Bafna Motors,
Well.
Mumbai Private Limited.
Well,
That itself says that is reported in 2024 to SCC page 1
well,
that says that the High Court was not justified in exercising its writ jurisdiction under Article 226 of the Constitution, more particularly when the borrowers had already availed the alternative remedy available to them under Section 17 of the Surface Act.
my problem is
That
that
is your decision which you are relying upon.
yes, my problem is that
You have already
this is my sole residence house.
maybe
Though I have taken alternative remedy, I have availed, but it has not been taken. My applications are pending.
application indicating the urgency to
Then also observe that in case of filing of an advance petition, that shall be considered by the learned tribunal and on urgent basis, the matter can be heard.
has been filed
Because bank has already appeared there.
by the petitioners with a prayer to set aside the notice dated 38/2024 issued by the opposite party bank with the vacation notice wherein it is indicated that since the petitioner has not paid the amount, the bank is constrained to take possession of his property under Section 13(4) of the Surface Act and realize the same towards the settlement of dues. And therefore, he was instructed to vacate the premises and furnish vacant and peaceful possession within 7 days from the date of the notice, failing which the bank would be constrained to dispossess him of the property with police protection. It appears from the averments taken in the writ petition that the petitioner has already approached the DRT which is the number you have given.
Paragraph 12, page 9, diary number 511 of 2024. Due to limitation, it has not been registered as essay.
Challenging the action of the bank in issuing the notice under 13 to rate with 13(4) of the Surface Act on 2/2024. And the same has been numbered as diary number 511 of 2024. It is further stated that in the said case, the bank has already entered appeal.
Yes. But objection has not been filed.
However, no objection has been filed by the bank. So, in the case of Serid LLP versus Bafna Motors, reported in 2024, bracketed to SCC 1. In the conclusion paragraph number 110, Roman dot 1 like that. The High Court was not justified in exercising its writ jurisdiction under Article 226 of the Constitution, more particularly when the borrowers had already availed the alternative remedy available to them under Section 17 of the Surface Act. In view of the above mentioned pronouncements made by the Honorable Supreme Court, and since the petitioner has already availed the alternative remedy and the matter is sub judice before the learned DRT Odisha Cutter, we are not inclined to interfere with the vacation notice dated 30/8/2024, which has been assailed here. The petitioner is at liberty to seek further relief before the DRT. The Land Council for the petitioner submits that since the case has been posted to 16/10/2024, he may be permitted to move an application for advancing the date to take up the matter, particularly in view of the issuance of vacation notice under Annexure 2. It is up to the petitioner to file such application before the learned DRT, and the same shall be considered in accordance with law. Accordingly, the writ petition is disposed of. Yes, obliged.
Item number 2.
May it please your lordship. Well, in this case, the petitioner prays for a mandate from this honorable court to the bank to stick to its one-time policy, which it has already entered into. One-time settlement it has already entered into between the petitioner and the bank.
Sale notice you are challenging.
Sale notice, my lord, sale notice. When I'm not a defaulter, they have issued a sale notice. I'll take your lordships to the facts of the case.
This very decision, Mr.
No, my lords, I'll show your lordships a judgment of Devidya and my lords.
110.3 that is stated.
My lords, I'll face Bafna, my lords.
Yeah.
I'm just, your lordships may kindly see the facts first, then I'll come to the.
Yeah.
Your lordships may see Annexure 8, running page 62.
Yeah.
There was a slight irregularity in the account, and my lords, we entered into a one-time settlement with the bank. The bank, in pursuance of its one-time settlement, entered into this memorandum, my lords. Your lordships may kindly see on 25/3/24. Lordship gets it. For my lords, as per your request letter dated 19/3/24 regarding one-time settlement of the outstanding dues of your above account, we are pleased to inform you that the proposal is permitted by the sanctioning authority subject to terms and conditions mentioned in the sanction. We have to pay 2 crores now. Permissions permitted to close the account before 31/3/25 with below mentioned payment schedule. Upfront amount of rupees 2 crore to be paid on or before 30/3/24, which we have done, and remaining amount to be equally paid in 4 installments up to 31/3/25. Now your lordship sees the first installment is on 36/24. We have already paid 3.23 crore plus interest already has been paid on 36/24. The next date is 39/24. Lordship gets it?
Yeah.
39/24. Now your lordship comes to the next page, that is Annexure 9. 4/9/24 letter. This has reference to, despite our my lords, they say that this has reference to trailing mail wherein repayment details of OMJ EV Limited has sent by email, for which balance payment to be made for first tranche of rupees 0.69 crore is still due as on date, and also intimated the total amount due for the second tranche as on 27/9/24 September 24 quarter for 3.23 crore plus accumulated interest. Despite a regular follow-up, the amount is still unpaid and there has been inordinate delay. My lords, third paragraph. In view of the above, you are hereby once again requested to pay 0.69 crore immediately without any further reminder. Also, company has to make for arrangement of second quarterly repayment amount of 3.23 crores plus accumulated interest due on 27/9/24 months. This my date is 27/9/24, and this dispute regarding 0.969 crores is, my lords. If your lordship sees Annexure 8 again, they say that the subject is permission for closing of account within 1 year at contractual rate. Contractual rate is 11%. Now they are saying 18%.
But that we cannot understand right now. How can we do that? The amount that you have agreed on the basis of your letter dated 25th of March 24 has to be complied. That 69 lakhs.
Now your lordships may kindly see Annexure 10.
No, when Mr. Kanungo,
My lord.
this is Annexure 8 is the bank's letter to you,
Yes.
Yes, my lord.
right?
Yes, my lord.
So,
I've already paid the amount, 2 crore.
That's
that is
16.
the
That's
that
16.
is still outstanding.
Uh.
If you see, you have that 2 crore has been paid. You say then the next one is to be paid by
3 crores I've paid.
plus interest.
Plus
You-
interest, my lords, there is a difference.
Perhaps you have not paid, and that is how the it is mentioned that what
0.69 lakhs I have to pay.
Right.
Now, my lords, they give me time. Your lordships may turn to Annexure 10.
Oh,
Page 65.
yeah.
This has reference to the above subject. Your lordships may kindly come to in view of the above. The fourth paragraph. Lordship gets it?
Yeah.
In view of the above, you are hereby once again requested to pay 0.69 crore immediately without any further reminder. Also, company has to make further arrangement of second quarterly payment of rupees 3.23 crores plus accumulated interest, which falls due on 27/9/24 well in advance as per breakup schedule detailed 1.65 crores before 15/9/24 and 1 before interest
59 is already over, Mr. Kanungo. Have you paid this amount?
1.65 crores I'm paying.
Then the earlier amount was also due, and then they give you this letter. 6/9 they issued this letter, and 9 days time was also granted to you to deposit that 1.65, and that is 1.68. They break it off that 3.23 break korigini
And
with accumulated interest. So you have not paid.
no, your lordship.
Now what you are challenging here now?
Please note, in any case, the company fails to make the required payment of, as mentioned above. That means they include the entire thing on or before 27/9/24, which has not come. We will be bound to take physical possession of the scheduled properties and without any further notice reminder. So they give me date till 27/9/24. Now your lordship sees Annexure 11.
Yes.
14/9.
Hmm.
They have issued this notice for
This 69 lakhs, then you could have said this.
No, my lord.
Had this 69 lakhs been paid immediately within this period before this notice was published, Annexure 11. So this amount was to be paid before 14/9.
I have already paid the entire amount, my lord, and 0.69. They have extended it to 27/9/24.
That they have not extended. According to you, there is some discrepancy in your calculation. So that should have been reconciled only after the deposit. You could have reconciled it.
Your lordship sees, please note, in any case the company fails to make the required payment of, as mentioned above, on or before 27/9/24.
For that you did. You are hereby once again requested to pay.
My lords. That is what my entire grievance is. If by 27/9/94 I do not make these payments, then certainly they have every right. On 14th, then what made them issue this sale notice on 14th? Are they fortune tellers that they will know I will make a default if, as your lordship is saying, 15th you should have deposited this? Then are they fortune tellers that they will know that by 15th I will not deposit these amounts?
That is your appearance.
No, that is not there. That is not there.
I deposited it on 15th, but they issued the notice.
I am not receiving it, but the instruction paper, they have given the due minutes. They have challenged the minutes option notice. So section 17 is there.
No, that please see the they got a copy there.
Again,
Come to these two letters which have been shown by Mr. Kanungo. Come to Annexure P. Page is 62. Yes. Please see, this is the letter of the bank. Bank से जो परमिशंस रे हेडिंग रे जहाँ लिखिले से कहउछंती 2 कोटी टंका अपफ्रंट अमाउंट आपनको पेमेंट करिया पड़िबो 30/3/2024 रे रिमेनिंग अमाउंट को चारिटा इंस्टॉलमेंट रे पेमेंट करिवे एंड लास्ट डेट होची 31/3/2025 Mr. Kanun को make a submission makes a submission this 2 crore has already been paid. Right.
Yes, in respect of first installment, that is by 30.
Just we are coming to that. The first installment is to be paid on or before 36/2024.
Yes.
What he says that he has already paid, deposited this 3.23 crore.
Not within 36/24.
No, we do not.
June.
Because the letter which has been issued, that is Annexure 9.
Yes.
Please come to that later.
Yes.
Annexure 9 देखुची जे आपनकर सी जो अमाउंट जोटा फर्स्ट इंस्टॉलमेंट हो आउ 69 लाख आउटस्टैंडिंग राइट ओके जदि 69 लाख आउटस्टैंडिंग रहिला ताहले आपण चिट्ठी पुनी नेक्स्ट लेटर तांको देले Annexure 10 Annexure 10 ता देखो तो डेट ता देखो केबे
6 नंबर बीच में
6 नंबर 2000 बटन पड़ेसन से जो इन व्यू ऑफ द एबव पाकू पड़ेसन
okay we have one second requested to pay 0.69 crores lakhs immediately without any further reminder. Also, company has to make further arrangement of second quarterly payment of 3.23 crores. Plus advance interest. That amount has not been paid.
So this 69 lakhs is of the first quarter.
69 lakhs टा जो फर्स्ट क्वार्टर अपन तो टाइम कितने केबे देले
Immediately.
बाकी जो 3.23 प्लस accumulated interest को से डिवाइड कर देले जे ता देर होची 1.65 crores को आपण 15 भीतर देबे 1.68 crores को 25 भीतर देबे so Mr. Kanungo is it your case that you have already deposited 69 lakhs
No, we have not deposited because they have issued
and have you deposited 1.65 crores
Your lordships, if at all I was to deposit on 15th.
No. 59 होची से जो 3.23 crore 3.23 crores plus accumulated interest ସେଇଟାକୁ ସେମାନେ fraction କରିଦେଇ breakup କରିଦେଇଛନ୍ତି
ଏଇଟା ମିଶେଇକିରି 1.65 crores କରିଛନ୍ତି
କୋଉଟା no that is
0.69 without
ଏଇଟାକୁ ଆପଣ ମିଶେଇ ଦିଅନ୍ତୁ 1.68 plus 1.68 ଏଇଟା ହେଇଗଲା 3.23 plus interest along with the interest ସେ ଲେଖୁଛନ୍ତି before so and so then ତାକୁ breakup କରିଦେଲେ ଦିଟା କିନ୍ତୁ so far as 69 lakhs is concerned that was 6/9/2024 ରେ ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା immediately deposit କରିବା ଆପଣ ଯେହେତୁ immediately କଲେ ନାହିଁ ସିଏ 14/9 ରେ option
if my lords 14/9 the date ଯଦି କଲେ should they not follow the entire gamut of the SFAC Act ଆମକୁ notice ଦେବେନି ଯଦି let us say I have defaulted failure of repaying that 0.69
ଆପଣଙ୍କୁ ଆଗରୁ କହିଥିଲେ ସେଇଟା ଫେଲ କଲେ ଆପଣ ପୁଣି ଆଉ ଗୋଟେ ଆପଣଙ୍କୁ ଅପରଚ୍ୟୁନିଟି ଦେଲେ 6924 ରେ ଯେ immediately payment କରନ୍ତୁ ତାକୁ ବି ଫେଲ କଲେ
I'll give it today sir 0.69 close the other
now you come to that Bofna case which you are
case my lord Bofna case
paragraph number 110.3
yes my lords Bofna case your lordship sees
yes. Come to that 110.3
yes
the Bofna case no I think
Bofna case
भाई बफना केस टा बाहर करो ये जो 2024 वर्जन अनुपात दो एससीसी ऑनलाइन अच्छी सेठी एठी एससीसी ऑनलाइन अनुपात अनुपात economy of right assumption ICC online ତା ଦେହରେ ଅଛି login କର find by citation. Find by citation this one, yes. Let's see now. That the right of the borrower to redeem the secured asset stands extinguished thereunder on the very date of publication of the notice for public auction under Rule 9(1) of 2002 rules. It is not till the completion of the sale or transfer of the secured assets in favor of the auction purchasers. That is amended provision in view of this they have interpreted that this moment it goes that then this cannot be done and the alternative remedy is there. So
No, my lords, my
and
commission.
particularly on the face of their letter which you are placing,
Yes,
you have not fulfilled the whatever agreement or whatever
my lords, but in
under
my
commitment.
lords, your lordship sees the action. If at all there was a default of 0.69 lakhs, then my lords, is it not incumbent upon them to bring it to a notice that no,
Clear that they will not remind you. That made it very clear.
maybe my lords, what your lordships are saying, because my lords, on 14, before the due date arrives, they issue this, my lords, for example, I'm giving your lordships an example, I am paying everything up to date, and suddenly they issue a notification in the newspaper that we are going to sell off your properties.
Mr. कानून को 6(9) ने ଯେତେବେଳେ ସେମାନେ ସେକେଣ୍ଡ ନୋଟିସ ଟା ଦେଲେ annexure 10 ଯୋଉଟା ଆପଣ ପ୍ରେସ୍ କରୁଛନ୍ତି ସେଠି 69 lakhs ଟାକୁ immediately ଆପଣ ଦେବେ ବୋଲି କୁହାହେଲା ଆପଣଙ୍କୁ ଆପଣ ସେ ପାଇଲେ ମଧ୍ୟ ଦେଲେ ନାହିଁ ତାପରେ ଆପଣ ଗୋଟେ ଡେଟ୍ ଥିଲା 15/9/2024 ସେଇଟାକୁ ମଧ୍ୟ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଦେଇନାହାନ୍ତି So 69 lakhs ଯଦି ଆପଣ comply ନ କଲେ ଆଗରୁ ଗୋଟେ letter issue ହେଇଛି ତାପରେ ସେମାନେ auction sale notice କଲେ ତେଣୁ what fault lie you there? How can you they say that yes statutory provision has not been complied with?
My lords, if 15th 9th date thala, then how can they issue a notice on 14th? I understand post 15th
it was the second installment Mr. Kanun को 15/9 ଆଉ ଯୋଉ date ଥିଲା ସେଟା break up କରି ଆମେ ଆପଣଙ୍କୁ କହୁଛୁ ହଁ सेटा is second, but you have not cleared even the first installment.
The first installment is cleared, 362 crores and 323. Only there is a discrepancy. I have cleared it at 11%. They say 18%.
That we cannot entertain. You have this.
But
interest
is quantified at the time of my lords granting the OTS.
In any case, if the 69 lakhs would have been paid under protest till the reconciliation of the calculation, it would have gone in your favor.
In spite of that, if they would have issued the auction sale notice, then it would have been different. But you have not paid. Even as on date also you have not paid.
But then your lordship sees the last paragraph of Annexure 10. Please note that in any case, the company fails to make the required payment of, as mentioned above, on or before 27/9/24, we will be bound to take physical possession of
action will be next.
Now, my lords, required payment as mentioned above includes all these payments, my lords. Lordship sees the last paragraph.
Once this type of matters time without number, it has been held by this court, by the Honorable Supreme Court, that in spite of our orders, high courts are entertaining and gone to the extent of saying that.
May I just explain to your lordship, my lords, if suppose, my lords, as your lordship is saying, I have failed to make a deposit of rupees 0.69 lakhs and thereby become a defaulter, then by annexure 10 they would have said, sir, you have failed to pay 0.69 lakhs, you are a defaulter, we are taking action immediately.
They have already
don't do
said
that.
They have already said that.
No, my lords, what
You
I'm
see-
saying is, you are again requested to pay 0.69 without any further. Also, company has to make further arrangement. Please
out
note
annexure
that
9
yes.
annexure 9 ଦେଖନ୍ତୁ annexure 9 ଲେଖରେ ଆପଣଙ୍କୁ ପୁଣି ଗୋଟେ ରିକ୍ୱେଷ୍ଟ କଲେ 69 ଲକ୍ଷ ଆପଣ ଡିପୋଜିଟ କରନ୍ତୁ ୱିଦାଉଟ୍ ଫର୍ଦର ରିମାଇଣ୍ଡର ତାକୁ ଆପଣ ଶୁଣିଲେନି ପୁଣି ନେକ୍ସଟ ନୋଟିସ ଆଇଲା 6 ତାରିଖରେ ସେଠି ମଧ୍ୟ କହିଲେ ଆପଣ 69 ଲାକ୍ସ ଇମିଡିଏଟଲି କରନ୍ତୁ ପ୍ଲସ୍ ନେକ୍ସଟ ଯୋଉ ଇନଷ୍ଟଲମେଣ୍ଟ ଅଛି ତା ଦେହରୁ ବ୍ରେକଅପ୍ କରିକିନି କହିଲେ ଏତିକି ଏତିକି ଆପଣ ତାକୁ ବି ଆପଣ ଦେଇନାହାନ୍ତି
Lordships may see the last paragraph. That has to be read along with the other paragraphs. My lords, my humble submission, again, your lordships may note down that even if I was a defaulter, then they had to follow the procedure under the Surface Act.
The petitioner, Messrs. Om J. EV Limited, represented by its Managing Director, Mr. Horst Ridwania, has filed this petition for quashing the sale notice dated 14/9/2024, as well as the entire surface side proceeding initiated. And with a further fair, to direct the opposite parties to act pursuant to the sanction memorandum dated 25/3/2024 and later dated 25/9/2024. That is Annexure 8 and Annexure 10 respectively. Mr. Milan Kanunbol and senior advocate during course of argument pointed out Annexure 8, which is the sanction memorandum issued by the bank dated 25/3/2024, wherein under the heading of permissions, it has been mentioned that the bank has permitted to close the account before 31/3/2025 with below mentioned payment schedule. Upfront amount of rupees 2 crores to be paid on or before 30/3/2024 and the remaining amount to be equally paid in 4 installments up to 31/3/2025. That is so and so liquidate. The Mr. Kanungo further submits that though the petitioner has deposited the upfront amount of rupees 2 crores within the prescribed time, so also deposited rupees 3.23 crores before 36/2024. But since the interest rate is disputed, he could not, the petitioner could not deposit the interest. And therefore, a letter was issued by the bank on 4/9/2024 requesting the petitioner to immediately pay rupees 69 lakhs without any further reminder, and also to make arrangement for second quarterly repayment amount of rupees 3.23 crores plus accumulated interest due on 27/9/2024. He drew the attention of this court to the letter dated 6/9/2024 under Annexure 10, which further indicates that the 69 lakhs was requested to be paid immediately without any further reminder. And So far as the second installment is concerned, a breakup schedule has been mentioned in the said letter, that is 1.65 crore before 15/9/2024 and 1.68 crores along with interest before 25/9/2024. The Mr. Kanungo submits that when they ask the petitioner to deposit the breakup amount of rupees 1.65 crore before 15/9/2024, the issuance of auction sale notice on 14/9/2024 under Annexure 11 is illegal and therefore it should be set aside. When we put a pertinent question to Mr. Kanungo as to whether 69 lakhs have been deposited, the answer was in negative. When we asked a pertinent question, further question to Mr. Kanungo, whether by 15/9/2024, rupees 1.65 crores, as has been mentioned in the letter dated 6/9/2024, has been paid to the bank, the answer was in negative.
Just two things, Manoj. My explanations also may be recorded.
The-
Manoj, 1.65 crores is on 15/9/24. As the auction notice was issued on 14/9/24, we did not. That is Annexure 11.
In the case of
My explanation may be recorded.
in the case of PHR, Invent Educational Society versus UCO Bank, reported in 2024, 6 SCC 579. It has been so also in the Celir LLP versus Buckner Motors, reported in 2024 to SCC 1. It is held that the High Court should not entertain the rate jurisdiction under Article 226 of the Constitution when alternative remedy is available under Section 17 of the Surface Act. In the case of Jajpur Vidyut Vitaran Nigam Limited versus MB Power, reported in year 2024 Supreme Court 7-1, it has been held that when a right is created by the statute, which itself prescribes the remedy or procedure for enforcing the right or liability, resort must be to that particular statutory remedy before invoking the discretionary remedy under Article 226 of the Constitution. In the Buckner case, Supra, in the conclusion part, paragraph number 110.3, it has been held that the amended provision of Section 13(8) of the Surface Act make it clear that the right of the borrower to redeem the secured asset stands extinguished thereunder on the very date of publication of the notice for public auction under Rule 6191 of 2002 rules. It is not till the completion of sale or transfer of the secured asset in favor of the auction purchaser. Since alternative remedy is available to the petitioner before the DRT, and in view of the letters, a sanction memorandum, so also the letters issued by the bank, we find that the petitioner has not paid the agreed amount within the stipulated period. We are not inclined to entertain this petition. The petitioner is at liberty to oppose the alternative remedy. Take recourse to the alternative.
My lords, just two points your lordships may record.
Yes.
My lords, this payment which was not made on 15/9/24,
Yes.
that 1.65 crores, is because Annexure 11, that is the notification, was issued on 14/9/24.
Mr. Kanungo said that the petitioner has got valid reasons for not depositing the interest amount of rupees 69 lakhs. So also in depositing the amount of rupees 1.65 crores before 15/9/2024. That those grounds can be very well taken before the alternative forum, and it is up to the DRT to
And my lord-
consider the same in accordance with law, which we are
And my lord,
expressing
this
no opinion
breakup-
on this same.
If
Yes.
your lordship sees the original sanction memorandum, the that is annexure 8, I was to pay.
Take all the grounds before the DRT, Mr. Kam. Yes.
My lord, just one paragraph, your lordship, may add.
Yes.
Just one line, my lord. That 3.23 crores, I was to pay by 39/24. There is no such breakup as indicated subsequent.
I say through the line that even though in the further summits that the sanction memorandum indicates that by 39/2024 rupees 3.23 crores plus interest is to be paid, and there was no breakup therein, which has been mentioned in the letter dated 6/9/2024.
Obligation. Obligation.
Item number 4.
Over, my lord, permitted to withdraw of an IA. This matter has been settled between the parties.
Petition has been filed for withdrawal of the writ petition on the ground of settlement between the parties. The prayer is made in the interim application is allowed. Writ petition is disposed of as withdrawn. Yes.
Madam.
Item number 5.
So last occasion I have given a detailed debt chart listing.
For this matter first.
Lordship, here Lordship, despite your Lordship's direction when the interim order was operating, they went for a sale. And Lordship, during pendency of the writ applications and application of interim order, they have also concluded the sale also, Lordship, and they have issued sale certificate. Subsequently, they have executed the sale deed, Lordship. And more interesting, Lordship, they have taken up entire amount from the borrower. And Lordship, they have also received the amount of the subsequent purchaser, Lordship. And without actual possession, Lordship, as it has been available under the statute, Lordship, without taking possession, Lordship, they concluded the entire sale process.
Just a minute. The order number 1,
Lordship.
that is dated 16/5/2022.
Lordship.
And this just it was mentioned therein that the execution of sale deed shall be kept in abeyance.
Abeyance, Lordship.
That was the only direction in that.
In fact, Lordship,
When the sale deed was executed,
sale deed, Lordship, they executed, Lordship, that is on 17/12/2021, Lordship.
No, prior to this, much prior. Even the possession notice was long back.
No, Lordship.
that means you have
Prior to that,
not
interim order,
mentioned,
Lordship.
Mr. Dalai,
Lordship.
that means you have not brought to the notice of this court when the order was passed on 16/5/2022 that sale deed has already been executed.
No, Lordship. In fact, Lordship, perhaps I am wrong, Lordship. Lordship, can I come to my debt chart?
You said
Prior to that is an interim order, Lordship.
16/5/2022 रे जो order टा pass ହେଲା
Lordship.
that the execution of sale deed shall be kept in abeyance.
Lordship.
ଯଦି ଆପଣ honorable judges ମାନଙ୍କୁ କହିଥାନ୍ତେ ଯେ sale deed already November ନା କେବେଠୁ କହୁଛନ୍ତି?
No, Lordship. Can you come?
କେବେ execute ହେଲା କୁହନ୍ତୁ?
Lordship, that is 17/12.
17/12/2021 ରେ sale deed already execute ହେଇଗଲାଣି ବୋଲି ତାହେଲେ ଏଇ order ଟା pass ହେଇଥାନ୍ତା କି 16/5/22 ରେ?
No, Lordship, I am unable to convince. Lordship, I'll come to 13/9/2021. Richard page 3921. 21. In another read. Yes, Lordship. There is entry matter and a person Lordship direction. I deposit the amount and Lordship.
21 who read?
Lordship, that is 26724. Lordship, can you place my detailed ledger so I can convince Lordship the interest?
Read
Lordship.
3921.
3921. Page 3 I have given the chat, Lordship.
orderটা পড়ুন তো পুরা।
Lordship. Lordship, please the date chat, Lordship.
Yes, no. Read the order dated 13.
Lordship, I'll go to Lordship. Lordship, that is available page 12, Lordship. Having, I'm starting from para 3, Lordship.
Yeah.
Having heard learning counsel for the parties, we are the opinion that this matter may be settled out of the court in OT scheme. Hence, we give leeway to the petitioner to file application for OTS, refreshment, resettlement, reschedule of the loan within a period of 2 weeks from making upfront deposit of rupees 8,50,000 only before the opposite party bank. On such event, his application shall be considered according to law and as per guidelines of the Reserve Bank of India. We hope and trust that if any recommendation is made by the petitioner with the upfront deposit mentioned above, within the time stipulated, the bank shall not take any further coercive steps against him. So, Lordship, first from this direction, Lordship, I deposited 8,50,000, Lordship, before the opposite party bank, and Lordship, because in that application, I had challenged the action notice, Lordship.
That amount was deposited within 2 weeks.
Lordship, immediately I have deposited, Lordship. Lordship, that are available in the entire register and Lordship, the entire.
Just a minute.
Lordship.
So now this aspect is not disputed.
No.
Okay. Then what happened?
Lordship,
That the upfront amount was deposited. Then the next order, the next line is that in such event, his application shall be considered according to law.
Lordship, because Lordship, due to delay in obtaining the certified copy, immediately I filed affidavit for the opposite party bank, Lordship. The order was passed on 13/9, Lordship. I deposited that affidavit on 15/9/21. Then, Lordship, 29/21, I sent it through post, Lordship, with my OTS offer. Then on 24/9/2019, Lordship, I deposited the entire amount, 8,50,000, before the opposite party bank.
8,50,000, he is not disputing that.
No, Lordship, this is sequential. What they did, Lordship. Then, Lordship, after the said deposit, on 16/10, Lordship, they issued a letter to me. Lordship, kindly come to Lordship that letter that is available at.
So on your OTS proposal,
Lordship,
when you got the first information from the bank, intimation from the bank that whether the OTS proposal is acceptable or not acceptable, and what would be the terms and conditions?
Lordship,
what is that letter?
Lordship, they did not do that, Lordship. That's why I filed a contempt. Lordship, kindly come to Annex 12. Page 53. In accepting rupees 8,50,000 in my proposal, Lordship, this is the reply. Then I immediately came to court by filing a contempt and subsequent writ application, Lordship.
That's all right. You filed a contempt.
What that Lordship tells you on the contempt of page 53, Annex 12.
No, you mean to say, let us be clear.
Lordship.
8,50,000 ସହିତ ଆପଣ OTS application ଦେଲେ.
Lordship.
ସେଇ application ଦେଲା ପରେ ଆପଣ ବ୍ୟାଙ୍କ ତରଫରୁ କୌଣସି intimation ପାଇନାହାନ୍ତି ସଂକ୍ରାନ୍ତି ଆପଣଙ୍କର OTS proposal acceptable?
Nothing.
Yes, Mr.
Then it should annex
step by step.
The fact of the matter is, my lord, he has deposited this amount on 24/9/2021. And this order was of the Honorable High Court was produced on 29/2021. Okay. By that time, The auction was held on 15/9/2021. And my friend has in the affidavit in the writ petition says that he has produced this order of this honorable court on 15 at 10:30 a.m. before the bank. And in the date chart, he has mentioned 3 a.m.
One thing is correct that as we find that this order was in the absence of the counsel for the bank. It was on the first date this order was passed. So it was up to the petitioner to bring this to the notice of this order. So that has not been brought immediately.
On 16th he produced.
By that time you mean to say that that has
on
already.
15th the auction was held. Now thereafter on 20th, your lordship may kindly see what he has done, my lord. He has also sent this honorable court's order on 20th, which was received by the bank, my lord, on 21st, my lord. That I have filed, my lord, by way of my this thing, my lord, counter to this, my lord, your lordship may kindly see.
It's all right, Mr.
But what has happened is
going this way. Suppose let us say there is a little late. It was order was passed on the very first day, and there was a direction. He complied it little late, but by that time you have already issued the auction service. So
we gave a chance, man. That is the letter 50, Annex 53, my lord, page 53, which my learned friend was showing. The lordship can kindly read the tenor of the letter.
53.
Page 53. That is the bank's letter.
Okay.
The lordship may kindly.
This was issued when?
This was issued on 16/10/2021.
Okay.
My lord. Your lordship may kindly see. After the auction was held, after 4 months, my lord. My lord. The auction was held on 15/9. Thereafter 16/10, after 1 month after. Now, this is to inform you that as per the order dated 13/9/2021 passed by the Honorable High Court, so and so, you were directed to make the upfront deposit of 8.50 lakhs along with liberty to file an application for OTS within 2 weeks from the date of the order, that is till 27/9/2021. This is to be noted that you had deposited 8.550 lakhs so and so as per direction on 24/9/2021. But we didn't receive any OTS application, my lord, from your end till the expiry of the time period granted by the Honorable High Court, that is 2 weeks from the date of the order. Therefore, it is clearly shows that you have failed to comply with the entire order passed by this Honorable Court, and you are always in the habit of following the court order piecemeal compliance, which is not accepted to the bank. Thereafter, my lord, under these circumstances, we would state that you are aware of the fact of the e-auction in respect of the mortgage property has already been conducted, and we have got a successful bidder for the said property, which is ready to make the entire payment of the entire overdue amount, along with the interim expenditure interest till date. And hereby we call upon you for the last time to make the entire dues to the bank along with the interest till the date immediately, or we shall make public proceeding under Surface Act 2021. And thereafter, my lord, we gave a chance of 1 month, my lord. And thereafter, we issued this sale certificate. Registration was conducted, my lord, executed. That was on 17/12, your lordship has already seen it, my lord, on 17/12/2021. So, my lord, this letter, which your lordship will find, 16/10, and the sale certificate is issued on 15/11/2021. Almost 1 month after, my lord. 1 month.
No, you 16/10/21 ପରେ କିଛି ରେସ୍ପନ୍ସ ନାହିଁ
କିଛି ଆଜ୍ଞା ଆସିନି ତାପରେ ସିଧା ଏଠି କଣ୍ଟେମ୍ପ୍ଟ ଆଜ୍ଞା ଆଉ 15/11/2021 ସେଲ୍ ସାର୍ଟିଫିକେଟ ତାର ପୁଣି ମାସେ ପରେ 17/12/2021 ରେଜିଷ୍ଟ୍ରେସନ ଆମେ ତ ତାଙ୍କୁ ଦେଲୁ ଚାନ୍ସ ତାଙ୍କେ ଦିଅନ୍ତୁ ଆମେ ଅଲରେଡି ଅପସନ ପରଚେଜର ଅଛନ୍ତି କିଛି ଶୁଣିଲେନି
Yes, Mr. Roy.
Lordship, can you come to Lordship, page 4 of the death chart, Lordship. Contempt order.
Death chart.
Death chart, Lordship.
Yes.
Lordship, my friend Lordship rightly pointed out the Lordship contents of the page 53, and Lordship, it in pursuit of my application under own admission, that is yet Lordship page 45. I must have 10 series. As page 45 of my brief, Lordship.
କହୁଛନ୍ତି ଆମକୁ ଡେଟ୍ ଚାର୍ଟ
No, sorry, Lordship. Sorry, Lordship. Lordship, can come to page 45. Lord, sorry, Lordship. Page 45. Because they are admitting, Lordship, they have accepted my proposal as under Annex 10 series. It is at page 45. Immediately after post direction, I approached before the opposite party bank with rupees 8,50,000 and my proposal and giving my consent to settle the loan account under the OTA scheme, Lordship. That is page 46.
So when was your proposal came?
Lordship, my proposal, Lordship, that is on 29, Lordship. That is, Lordship, that is on 29 or 21. They have, Lordship, accepted, and they're saying on 29, on 21st they have accepted. Lordship, as per course direction, and Lordship, I have given the Lordship the entire postal receipt, and they are saying, Lordship, we will receive on 21st. I have sent it on 20th, and they have received 21st. And from 21st till 16/10, Lordship, there is no communication. Either they have, Lordship, turned down my proposal, or they are saying to Lordship, because Lordship, can you remember, prior to that, I have sent, pursuant to court direction, I have deposited once 5 lakhs, then 4 lakhs, and I have offered my Lordship notice proposal, and they have turned down every time, Lordship. So this is third attempt, and by this attempt, Lordship, I gave a proposal with rupees 8,50,000.
Now this annexure 10
Lordship,
at page 45.
45, Lordship.
This speaks only about your deposit.
Deposit, Lordship, last line, Lordship, can see.
What is that?
As per post, last line, Lordship.
Read.
And they settle the loan account under the OTS scheme.
That is not. But OTS proposal you have to.
Lordship, usual Lordship OTS proposal. Last occasion, every occasion, Lordship, we have given a proposal. They have come down
to the order passed by this court.
Lordship, that's true, Lordship.
Direction.
Lordship, that is my understanding. If that is, Lordship, I have committed mistake, Lordship, definitely the bank should come forward to give me a proposal, Lordship. If they are going to turn down this, they are not understanding, Lordship, they are not going to settle the loan account. They could have been come with a letter, please give the proposal. Lordship, they have not done it. Straight away, Lordship, they have come with annexure 12, aspect 53, and they said, Lordship, we have turned down. We are not going to resettle the account, and you have come and deposit the entire amount.
Yes, proposal ଟା ଆପଣଙ୍କ ତରଫରୁ ଦେଲେ
Lordship.
ତା ଦେହରେ ଆପଣ ଲେଖିଥିଲେ ଯେ ମୋ ନାଁରେ ଯୋଉ ଏତିକି ଏଗେନଷ୍ଟ ଏତିକି ଆମାଉଣ୍ଟ ଅଛି ମୁଁ ତାକୁ ଏଇଭଳି ଦେବାକୁ ସକ୍ଷମ.
No, Lordship, that I have not written. That I have not written, Lordship.
That is not yes.
So my humble submission, Lordship, that is human error, Lordship. Because the person is not competent, Lordship.
You are resorting to the court of law and you are.
No, I'm saying that, Lordship. My humble submission, Lordship, while issuing a letter on 16/10/21, they could have been said a letter, Lordship, Lordship, kindly come to set up the before, Lordship, on 2 to 3 documents.
Let us be clear.
Lordship.
Order of this court was that you are to give the proposal,
Lordship.
not the bank.
Lordship.
So ଆପଣ proposal ଦେବେନି ଟଙ୍କାଟା ଡିପୋଜିଟ୍ କରିବେ ତାହେଲେ କେମିତି ହବ? ଆପଣ proposal ଟା ଦେଲେ ସିନା ବ୍ୟାଙ୍କ ତାକୁ କନସିଡର କରି କହିବେ ନାଇଁ ଆମେ ଏ ପ୍ରସ୍ତାବ ସହିତ ଏକମତ ନୁହଁ. ତେଣୁ ଆପଣ ଯଦି ନ ଦେଇଛନ୍ତି ତାହେଲେ ବ୍ୟାଙ୍କର ଫଲ୍ଟ କୋଉଠି ରହିବ?
I come to that. What is the Lordship? I come to page 29 for a moment. Page 29.
Yeah.
Lordship, this was the prior to LA debt application. The Lordship directed to deposit me 5 lakhs with OTS proposal. Lordship, kindly, this was the contents of the letter which I had given, Lordship. Page 29. Lordship, I had given, Lordship, as per Lordship, I am giving the second, as per direction of Honorable High Court of Orissa, I deposit rupees 5 lakhs in the opposite party account of Binodin Rautara of your bank on 18/1/20, which clearly shows my clear intention to settle the issue. Still, we are going through very bad financial condition as of now. We are requesting for one-time settlement of the loan account, and we had paid the interest for the said loan amount in time. But due to health condition and business crash, we could not able to pay further. So kindly looking for a final condition, settle the loan amount with 50% waiver and allow us to clear the dues within 1 year. Then also kindly come to, I deposit 5 lakhs, page 30, page 31, the letter of the bank.
No, this is not in consonance with the order passed by this court.
No,
This is an earlier one.
earlier one. I'm Lordship, beginner Lordship's kind notice the communication.
Because the bank did not adhere to your proposal at that point of time.
Lordship.
Again, he resorted to the petition. And after the writ petition, where it
what I'm trying to convince you, Lordship.
Then what was the need for the...
No, Lordship. What I'm trying to convince you, Lordship, Lordship, can go to page 31. Despite Lordship...
It is not regarding...
No, Lordship, say that, Lordship.
You cannot blend all the orders together.
I'm not saying, Lordship. I'm only saying before, Lordship, earlier also, in complying with Lordship's direction, I had also given a...
But that is not accepted. Because it was not accepted, you have to file another way.
That's true, Lordship. That's true. So my humble submission, that was the same manner, that was my application was very same. And Lordship, they had responded to my application at page 31, not only once, Lordship. If 31 also they said, no, this amount is very too. Yes. So they are very then Lordship kindly come to next annexure 6. Annexure 6 Lordship also, page 32. Again, person's court direction, I Lordship, again I gave the offer, the same language Lordship. I am ready to settle the loan account and take the my offer. And I have deposited another 2 lakhs. Then Lordship kindly come to page 33. Page 33 also Lordship, the same language Lordship they use. They have turned down my application. So my humble before Lordship, when I gave the proposal and by using same language as Lordship, as per page 35, they could have been communicate me that they are not going to settle amount. You give the entire amount. Or without saying so, Lordship, they state a comment in annexure 12 that pay the entire amount because you did not offer the proposal. So that's why Lordship, I came with the content petition. The direction of court of the settle loan account, you can say to give the entire amount. That's why Lordship, that's why Lordship, can consider one moment. That's why Lordship, I am saying this order is in content the direction of Honorable High Court. And I came up with a content petition, and while dealing with the content petition,
had the order been to comply the earlier proposal that you have submitted, along with depositing rupees 8,50,000,
yes,
then if the bank would not have come, we could have said that yes, bank has violated.
no,
Because your proposal was already there with the bank.
Right.
Had it been so, correctly, it would have been considered.
Absolutely.
Now the proposal was
I'm not going to technical Lordship, but Lordship kindly see, the court's language is very clear, Lordship. I will deposit 8.5 lakhs, and I will try for settlement. Lordship, both the parties come forward for settlement. Lordship,
File a phrase, that is the language is very clear. You just precede that order.
Lordship,
The order, where is that order?
that is just page 15, Lordship.
On the file.
Page 12, Lordship, that is page 12, sorry. Hence, we give liberty to petitioner to file application for OTS
Say your language.
which from by making upfront deposit such and such. Next paragraph, paragraph 4. We hope and trust that if any representation is made by the petitioner, that's with the upfront deposit mentioned above within time of stipulated, the bank shall not take any further course of action to against. So my application has page 45 with deposit upfront amount of 8.50 lakhs, Lordship. Then Lordship, they did not communicate me anything by accepting that letter in 1610. Lordship, kindly see, they waited the period to be expired. Had it been a case, Lordship, by showing that bona fide bank would have been issued a letter to me to give a proposal, Lordship, the matter could have been different, definitely, Lordship, because I am a law-abiding person and every moment I am trying to settle the loan account. But they did not do that. They issued such letter by giving ultimatum that because we have already achieved a successful buyer, you match the entire amount. So Lordship, that's why Lordship, I approached the Lordship and Lordship directly deposit the entire amount. And I deposit the entire amount before bank, Lordship. Now Lordship, along with interest, the entire amount is now with bank. They have received my amount, entire amount, and also they have accepted the amount of the successful bidder, Lordship, the subsequent purchaser. Then Lordship can be seen. Now Lordship can be seen last occasion, your Lordship directed only to, because my entire contention was with your Lordship, the entire money you have accepted from me, and the land in question is my possession. Still, you have not taken that actual possession, Lordship. As laid down under the statute, Lordship, can come to for a moment, Lordship. Rule 8 of the Lordship. Security interest enforcement rules 2002, Lordship, for a moment, Rule 8 for Lordship, can listen.
Yes.
Lordship. That's a real sale of immobile secured assets. The rules prescribe for how they will, Lordship, when they can, Lordship, take the possession of the land, Lordship. Lordship, once speaks, Lordship, where the secured asset is an immobile property, the authorized officer shall take or cause to be taken possession by delivering a possession notice prepared as nearly as possible in Appendix 4 of these rules to the borrower, and by affixing the possession notice on the outer door at the such constitutional place of the property. Then 2, the possession notice is required to in sub rule 1 shall also be. I am in possession. So 3, Lordship. 3, Lordship. in the event that possession immune property is actually taken by the authorized officer, that is the language lordship, that is the mandate of the statute, there must be actual possession to complete the sale lordship. And the lordship, to confirm my argument, lordship, can you see the section 13 and 14 is also very important. They never refer to that section 13 and 14. In lordship, the 14, there must be order of the CJM by taking possession, lordship, that is the chief magistrate or district magistrate, to assist secured creditor to take taking possession of secured asset. Lordship, till that lordship, no such lordship procedure they have adopted for taking over the possession. And lordship kindly say, in the circumstances when the after receive, if lordship they are saying that the person who deposited the entire amount subsequent, lordship kindly come to.
We are not adjudicating this matter, sir.
Lordship, we are here to adjust the lordship.
No. We cannot adjudicate at this stage.
Lordship, because lordship kindly see one aspect, lordship. When during in operation of interim order, when the case is under operation, lordship, I am also lordship the same judgment has been.
Interim order has not been followed by you.
Lordship, that's my lordship. I have deposited in time, lordship.
Yes, Mr. Rao. What is your submission?
Lordship, can I, lordship, only two judgments can I show, lordship, then?
Please,
Lordship, can you come to, please, let me complete that.
yes.
Lordship, can I just have state time, lordship, coming, lordship. The same judgment your lordship is relying. That is lordship, Bapna Motors, lordship,
Yes.
lordship,
Which paragraph you want to suggest?
lordship, para. Para lordship, 103 lordship. Though the judgment against in different context, but only lordship I borrow para 3.
You are relying from 105.
103 lordship. It was 102 and 103. Two paragraphs.
We are taking note of it. We are
Lordship, may I permit to read lordship?
Yes.
That is very important for me, lordship. The genesis of the entire case lie in legitimate conduct of the bank in placing different concerns above the clear provisions of law. Lordship, I given the copy also, lordship. Given as there was a failure on the part of the bank to issue sale certificate in favor of the auction purchaser, despite the fact that the entire payment of auction bid was made. Secondly, though the right of the redemption clearly stood lapses under the section 13(8), and first, then let's come to page 103. 103.
No.
Page 81, lordship. That page 81.
No. They come listed. ଅଧା ଏମିତି ଅଛି ଅଧା ଏମିତି ଅଛି କଣ୍ଟାକ୍ଟ ପୁଣି ଏମିତି ଆମେ ଦେଖିବୁ ନା
ଭୁଲି ଯାଇଛି
ଅଧା
ଏପଟରେ
କଣ କରୁଛି direction?
Page 81.
Page 81, lordship.
May I just hand over the AI version?
Lordship, 103.
Paragraph number would be
103 lordship, reading lordship.
Kindly read, sir. We have gone through it. You read.
The fact, lordship, I'm lordship, para 3, 1, 2, 3, 4, 5, 6, 7, 8. 8. The fact that, lordship, better lordship. No, more yet. The fact that the Reserve Bank failed to issue sale certificate raises serious concerns when there is no stay by any competent forum. Even otherwise, the general conduct of the Reserve Bank has not been satisfactory. On the entire bid price is paid and there is no stay granted by any forum known to law. So, lordship, my lordship, in this judgment also some protection for me, lordship, also. If there is some lordship direction of Honorable High Court or any court of law, lordship, any competent court, but here is a case, lordship, kindly see the unruly attitude of the bank. The rule of law should prevail, lordship, in the lordship state. Lordship, the one judgment of Supreme Court cannot take up the entire right of the Supreme Court.
That is not the only. That is not the only. That is not the only judgment, sir.
Lordship,
entire judgment.
Lordship, yes, my case, lordship, gives me protection. There is an interim order by this honorable court which protects my right, lordship. Then lordship kindly come to another judgment as judgment.
That interim order was passed in this case, particular case, and the entire thing was not brought to the notice.
Lordship,
we can use the word that the court has been misled to pass such order when the sale deed has already been executed.
Lordship, that was the entire contents of the recognition, lordship. Lordship, kindly see my
entire thing has been processed. The position notice was already there, you did not resort to the actual provision under the DRT, and you inserted only to the repetitions. See, how can it be?
Lordship, you should know, Lordship should know that what is
Yes.
that's another judgment, and that's the Lordship, because the Lordship is relying on Supreme Court judgment. That's a Lordship, another judgment is Lordship. Give me that judgment.
Yeah.
Of 2024. Lordship, can you see? For a moment. It covers that my case, Lordship. Kindly see. Lordship, it is the after this Lordship, Bafna judgment, Lordship, Bafna Motors case, Lordship. Lordship, didn't Lordship can permit the entire case, Lordship, because it covers the squarely cover my case, Lordship. Lordship, can you see the judgment, Lordship? Surinder Palsing versus Vijay Bank, Lordship. Lordship, kindly allow me to permit the entire judgment, so the very small judgment.
No, you just told.
Lordship.
But we'll go through it now.
The applicant has asserted the order dated sentences passed by the High Court of the Punjab and Haryana, Chandigarh, whereby the High Court dismissed the writ petition held by the appellant praying for quashing of order dated 10/15 passed by the Debt Recovery Appellate Tribunal, by which the tribunal and allowed the appeal of the borrower respondent 2 and 3 and permitted redemption of the mortgage property. The appellant had also prayed for handing over the vacant possession of the plot in question. The appellant was the action purchaser in proceedings under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act.
All right, we have gone to the material part of it. Paragraph 12, 13 actually are in
Lordship, grateful Lordship. In the net result is that right of the borrower of freedom will be available till the sale certificate is registered and the possession is handed over, after which borrower will not have a right to redemption over under the unamended provision section 13 of the Surface Act. Considering the above facts and circumstances of the case, we are not inclined to intervene the impugned judgment of order passed by High Court dismissing the writ petition. However, in the interest of justice and to do equity between the parties, we are of the view that the borrowers must pay a reasonable amount to the appellant. In view of the above, we dispose of the following directions. The bank respondent number 1 will pay the entire amount of the auction money along with accrued interest up to date within 2 weeks from the today, without making the deduction therefrom except TDS. No other deduction of any kind would be available to the bank. The borrower who responds 2 and 3 will pay the amount of rupees 7 lakh to the appellant within 4 weeks. In the case default, the amount payable such and such, Lordship. So, Lordship, in the present case, I have deposited the entire amount, Lordship. And Lordship, kindly another judgment of this honorable court also there, Lordship, I can brought to Lordship's kind attention. How they are interested, Lordship, to take over the possession when the borrower, Lordship, is interested and we given the entire amount. Lordship, he is a stranger of my property. It is my property, Lordship. I have purchased it for my personal use, Lordship. I can enjoy, Lordship. And Lordship, to that extent, I have given the entire amount along with interest and by safeguarding his interest also, Lordship. The entire, Lordship, kindly see, I have deposited the entire amount, including the taking care of the interest which is deposited by the subsequent purchaser. That's why, Lordship, this is my property, this is only my property. So, Lordship, the Lordship can directly to refund the entire amount with accrued interest by virtue of the judgment, Lordship, the apex court has taken a lenient view to only safeguard my property, Lordship.
Okay.
And so, Lordship, another point I have, Lordship, rightly point out, actual possession with me, and I have pursued their affidavit, I have given an affidavit, the property is still with me, and they have not followed they have not taken the actual possession. So, Lordship, they have not responded and they have admitted that I am in possession. So, Lordship,
Yes,
so, Lordship,
Mr. Rao,
the lenient view.
the submission which has been made by Mr. Dare, that he has deposited the entire that amount, the loan amount, this increased. Is it a correct statement?
Just to clarify that, during the pendency of the contempt petition, on 4/5/2022, that I have mentioned in my counter also, he has deposited 27 lakhs, my lord. The earlier direction was to deposit 8.5 lakhs, my lord. And if it is 27 lakhs which was deposited subsequently on 4/5/2022 during the pendency of the contempt petition, my lord, so it comes to 35 lakhs odd, my lord. That fulfills the outstanding.
Question. He is making a clear-cut submission that whatever was the due of the bank on the petitioner, he has already deposited it.
Yes, ma'am.
Is it correct?
That was deposited, but on 4/5/2022.
So now the bank is having the money of the petitioner with him. So
not the interest part which my friend is saying.
Yes, yes.
The interest part which my friend is saying, that accrued interest to be paid to the auction purchaser, my lord, that is not there. But he has deposited the outstanding dues as far as bank is concerned, my lord. On 4/5/2002, deposit of 27 lakhs, my lord. And my humble submission is this, my lord. With regard to the judgments which my learned friend has cited, your lordship kindly come to. I will not take your lordship, bother you, your lordship, with the documents, my lord. I will only say that my friend has shown your lordship two documents saying that earlier I had approached him in BAM.
No, so let us say.
Earlier, my lord, what has happened?
No, let us say we are giving an example. Let us say the outstanding dues with the interest on this petitioner was 100 rupees. Okay, he has given it to you. Now, from this auction purchase, you are getting rupees 200 rupees.
Correct.
Right? So, do you mean to say that you will retain the 100, so also the 200 rupees?
No way, my lord. That is the reason we have filed a petition, my lord, before this honorable court, saying because of the litigation, my lord, the entire amount, both the amounts have been kept in no lien account, my lord, because you don't know what is the direction, my lord.
No, that is why he is pressing this judgment.
My lord, so that judgment is different, my lord. I mean, differentiate, my lord. This judgment is not applicable to my friend, my lord, with all due respect, my lord. This partner, before your lordship goes, I'll take it to a judgment, my lord.
So the balance amount is to be given to the petitioner or not?
Yes, to be given, my lord.
So
because of the case, my lord, there will be a direction, my lord, if auction purchase is, my lord, settled with the thing, my lord, then, my lord, we have to deposit. Otherwise, my lord, we have. That is the reason we have filed a petition before this honorable court, my lord.
If at all, let us say that the sale deed is executed or whatever it may be. Now you are having the money of this auction purchaser.
Loan account, my lord.
So also the money of this petitioner with you.
And, my lord, we have filed a petition before this honorable court in this writ petition, my lord, that is pending, my lord. Your lordship may kindly see what is the prayer, my lord. Prayer is to graciously please to pass appropriate order with regard to dealing with the deposits made by the petitioner as well as the auction purchaser. That is what, my lord, we have come before your lordship to clarify the position, because, my lord, we are not because of the pendency of both these cases, my lord. Contempt petition was.
That is all right, but the fact remains that the position is still with you.
My lord, possession, what? This is an open land, man. This is an open land.
Yes,
it's
not a house.
Land. No. That is the reason, my lord. The facts are, my friends at the auction purchaser, my lord, who has purchased this property, is the adjacent landowner. He has constructed his house, my lord. That is what I have got the information during this interim period. My lord, he has participated and he has purchased, my lord. That land which my lord is a vacant land, man, open land. So section 14 doesn't have. Section 14 is basically to, my lord, to occupy the physical position of the house or shop and these things, my lord. This is, since it's an open land, the bank has not gone. So this is the fact of the matter, my lord. But what is, my lord, my humble submission, my lord, that, my lord, this, my friend, which my lord, partner motors, your lordship has seen. Now, my lord, this judgment which my friend has shown, the difference is this, my lord. This is a case prior to the 2016 amendment, my lord. This Vijay Palsu. Vijay. That is the reason, my lord, Honorable Supreme Court said that still the right of
title has not.
Yes, man. And the difference between Bafna Motors, my lord, your lordship, I'll take your lordship to Bafna Motors.
Say last paragraph is CRC.
Yes.
Again.
Amended provision on J.
Yes, my lord. Bafna Motors say 13/8, 16 to Delhi question. And all these measures, my lord, as far as bank is concerned, 2019 standards. So the right of redemption which my learned friend is claiming on the basis of this judgment, my lord, will not go, is not correct, my lord. And even if Bafna judgment also, my lord, is in 2023, by this time also, my lord, the entire process was over. I mean,
you have mentioned it that it's just a piece of land, no construction is there.
No, that I have not mentioned.
Lordship, I have mentioned, Lordship. I have specifically in my reply, Lordship. I have mentioned I am in possession. They are not, Lordship.
No, possession. What is the nature of the land? Is it a building is there or something? Or
Lordship, this will Lordship, it is with the boundary wall, Lordship, and that's it. That is.
But I am appearing for the
factual aspect किसी भूलभाल कथा हमें सुनियाକୁ चाहूँ जे जमीटा गोटे एमती फांका बाउंड्री देछि ना किसी घर होइकिनी
that's a vacant land adjacent to the land of the auction purchaser. So building of the auction purchaser. The auction purchaser is running a guest house, and now after purchasing the land, he has filled the sand and is using the land as parking.
Lordship, it is a wrong statement. Lordship, kindly on my cost, Lordship. Lordship, can take a commission. If that is true, Lordship, I will simply withdraw the case, Lordship. If the statement will found to be correct, Lordship, straight Lordship, I withdraw the case. It is a complete wrong and misleading statement, Lordship.
After
Rather, Lordship, I have constructed a POL, I have
We are
constructed.
not making to change.
Lordship, I will make a Lordship wrong first statement, Lordship. Lordship, Lordship, tell the conductor the day from the day one, Lordship is making a misleading statement. Day one, he made a statement, I filed a counter. Lordship, filed counter.
Submission, then we will have.
My counter, Miller,
Yes.
just complete, Miller. My counter, Lordship, can you see the prayer portion of the petition? It is challenging the auction sale notice, Miller. As per Bafna Motors and as per this, Miller, this is not maintainable petition, which I have mentioned.
That we have.
Yes, Miller. I need not go through that. Excepting that a right of redemption also it doesn't exist as on today because the Bafna judgment which says that 13.8 after the 2016 Miller the right of redemption once sale notice issued. And moreover, Miller, if your lordship will see the writ petition, not a single challenge to the auction sale notice or any process followed. Not a single challenge.
Already, what is your submission?
Well, your lordship may kindly see the counter filed by the opposite party number 4. But at paragraph 7 and 8 I have mentioned, sub 7, 8 and 9. Well, after purchasing the land,
Just come to that. Yes, 7, 8 and 9.
well, 7, 8 and 9.
Yes, what you have stated?
Well, I have thereafter the opposite party number 4 has deposited the entire bid amount of rupees so and so as said by the opposite party number 2 and 3, and thereafter the opposite party number 2 has issued the sale certificate on 15/11/2021 in favor of the opposite party number 4 and handed over physical possession of the property. Subsequently, on 17/12/2021, the opposite party number 2 has executed the registered sale deed by number so and so dated 17/12/21 in favor of the opposite party number 4. That it is pertinent to say that the opposite party number 4 has mutated the property in her name and has received the ROR in her name from the concerned office and is in peaceful possession paying of the debt revenue rent. That since 17/12/2021, the opposite party number 4 is in peaceful possession of the property.
ନାଇଁ କଣ ବାଲି ପୁରେଇ ଦେଲେ ତାକୁ ଇଏ କଲେ ସେଗୁଡା ତ କିଛି ଲେଖି ନାହାନ୍ତି
ସେଗୁଡା ଲେଖିନି, that is the
ସେଟା ମୌଖିକ କହିବେ
that is the factual aspect.
Yes.
Lordship, my reply is there, Lordship.
And your lordship,
I have given reply and they have not responded to that, Lordship. My reply, Lordship, can next, Lordship. Para 5, 6, Lordship, clearly I have mentioned, Lordship. They have not responded to this, Lordship.
କଣ ଲେଖିଛନ୍ତି ଆପଣ?
Lordship, kindly see that in reply to the averments made in para 7, it is only submitted that the statements made in para are not only false, fabricated, but also contrary to the law of land and statutory provisions as laid down under the law. Here the petitioner makes a reasonable statement. The land only property in question is still under possession and the statement advanced by the opinion of 4 is false and hereby denied. Then para 6, Lordship, kindly see. That is humbly submitted that the opposite party number 4 has given a statement relying upon the lines of printing form of such certificate without ground reality, and the petitioner once again confirms that till date the actual possession has not been taken over by the opposite bank in conformity with the section 14 of Surface Act and rule 8 of the Security Interest Enforcement Rules on 2. Lordship, kindly see the printed form, the self-cited form. There is a form, Lordship. There is a printed form. They are taking recourse of taking advantage of that printed form, Lordship. There is a possession language they have used possession. They have only the purpose of to construct a Lordship document. Only they have done this. And Lordship, my humble submission of Lordship, when I have deposited the entire amount, and why they are taking bank is taking interest, Lordship, and the interest of this person, Lordship. When they have taken the entire amount, Lordship, he still interest in favor of the Lordship subsequent purchaser who because he has to that person, Lordship. So that is the entire Lordship should interfere in some cases. Although the bank official go, Lordship, to any extent to humiliate every citizen of this state, Lordship, the country.
Mr. Rao, the submission which you made that this 14 is applicable only for this building, etc., and not.
No, that is not my humble submission that we have not gone for 14.
A submission.
We have not gone for 14.
No. You have not gone to the 14. You made a submission that 14 is applicable where the this.
No, I didn't say so, my lord.
You are backed out. You are backing out from your submission.
Because it's a vacant land, my lord. We have not gone. That is my submission, my lord. And section 14, my lord, taken instruction, bank has not taken physical possession of the property because it's an open land. That is what I have telephonically.
Somebody is in physical possession, so you will not take recourse to section 14 and hand over the same to this one in accordance with law. There is a prescribed procedure. So how can it be said that he is in physical possession? ଆପଣ ଏଇଟା କଣ ଗୋଟେ ଜିନିଷ ହେଇଛି ନେଇକି ମୁଭେବଲ ପ୍ରପର୍ଟି ନେ ତୁ ନେଇକି ତାକୁ ନେଇ ଦେ immovable property right?
Because there are income.
There are procedure.
You cannot assume the position without
that is
that being delivered.
You might have executed a sale deed, it's all right, but for delivery of possession, certain prescribed procedure has been there in that act.
This is the act.
So that you have not taken recourse to.
You are an authority acting under a statute. You can't go.
The act in the section 14 is not mandatory matter. That's what you thought. It's not mandatory matter.
Submission that is in physical possession. Now the other side is also making admittedly he
is in position. He's saying.
Is in possession. So unless you merely that you have executed the sale deed, does it mean that the physical possession has been handed over to him unless you take recourse to this other methods which are available under law?
Section 14 we have not gone.
Then
actual physical possession we have not taken. But if the factual aspects I am saying, well, since I have taken instructions that since an open land, the bank had not gone to section 14. Section 14 also uses the
word. What is the submission is made that there is a boundary wall. If there is a boundary wall, we do not know how that the sands have been filled up as he stated.
There is no boundary wall. There is no boundary wall. There is no boundary wall. There is no boundary. It's a vacant land adjacent to the opposite pattern of force land. There is no boundary wall.
That boundary wall lordship having wall and there is
all right. We are resolving the
lordship. That's lordship.
Hard this one so Mr. Sukandari for the petition. Mr. N. Balakrishna Rao for the bank. And you are for the whom?
I am for the number 4.
OP number 4. Yes, hearing is closed.
Gratefulness. Entry model that is
yes, yes. Let's entry model to continue till pronouncement of the judge.
Gratefulness.
We are just coming within 2 minutes.
Weekly list, pass over item number 9.
My lords, I have gone through the instruction. My lords, I need some time to file the rejoinder.
What order was passed? Submit the email given some further time in terms of obtain instruction. Oh, you have?
Yes, well, I have given the instruction, Lordship.
Yesterday, my lord, I was given the instruction yesterday. Let him file it. He'll file the rejoinder.
The Land Council for the state, as per the order dated 3/9/2024, submitted the instructions received from the opposite party number 2, Collector and District Magistrate Board, which is taken on record. The copy of the same has been served on the Land Council for the petitioner to seek some time to file resenter affidavit. How much time you require?
My lord, 2 weeks.
2 weeks time. Put up this matter after ensuing Durga Puja holidays.
Obliged, Lord.
Item number 44.
Sir, item 44, before my friend actually begins, but I submitted if you lordship that the date is fixed to 30th, yesterday. But I got the certified copy of the last order, which, if lordship can see. The date has been fixed to 20th. That is tomorrow.
No.
But this, I'm sorry, I submitted 30th. That is the exact correction I made. But let me submit to one thing, Lord. But here in this case, let's kindly have a look at that the tribunal has directed.
But I do not happens on 20th. Let us see. We are taking up this matter next week. See that.
Sir, I'll just submit one thing, Lord.
Yeah.
I filed an application for inclusion of party that has been kept pending. You said I taken on record, no order has been passed. Then I filed an application to implement the order as the lordship's previous direction. That has been kept on record.
You can move the application tomorrow itself. That don't keep it on record. Pass on tomorrow whether you are to amend or give the permission to add it as party or not. So we cannot say that what you are required to be done. But when the matter is posted to tomorrow, we are just keeping it to Tuesday.
So I'll just last order kindly have a
Yes.
the order I give worship. Kindly have a look at first. May I just read it, Milord? I filed 2 applications on that day.
Yes.
The case record is put up today. The obviously government leader, Sri V. is present. Sri Omkar Panda is present in the appellant. He submits 2 applications. First application to supply a copy of LCR 10824. LCR in Paragambu comment and a report from the opposite party. So
Mr. Mishra, you smell some arbitrariness in the order. Obviously, there was nothing before the court even to get out of the status quo order. There was nothing like that. It could have been proceeded with.
So, and second thing, you have dispensed with that LCR and the foreign comment.
Nothing was before the court by then. In fact,
and the proposal of court says that everything is there.
So, all right, we are monitoring it. My lord is saying, we'll fix it to day after tomorrow, we'll see. In case anything goes, we'll see. We're monitoring it. Understand.
Have a small
Very thing.
Whoever the court is supplying, who the matter. Nothing is there.
Let us see that what he is doing.
My lord, keep it to 24th. 24th, I have.
It is brought to our notice by Dr. Mishra, Joint Senior Advocate, that the case is posted tomorrow, that is on 20th of September 2024, before the RDC Central Division Cutter. The case means there are on the OGLS appeal number 5 of 2023. Bracket like the Roots Corporation Limited versus Schwanz, in view of such submission put of this matter. On 25th of September 2024, both the parties shall apprise this court about the development of the in the case before the RTC. Yes.
Only thing I'm asking Mr. Lord, can you just submit me?
Yes, yes.
So tomorrow the court will you argue.
No.
Committee
I do not know.
We'll take care of it. We'll take care of it, surely.
Good. Yes.
Item number 39.
May I please,
Lordships directed the Lord State Council to examine and submit, my lord.
Yes, which matter?
49 maps.
Yes.
My lord, on the last date, my lord, yesterday, your lordships directed the Learned State Council to examine and submit, my lord. May please the facts, my lord, my grievance. The question that fell for consideration before your lordships, that once the lease has not been granted under the OGLS rules 1983, which came into force with effect from 12th March 1984. So the very initiation of the proceeding under section 3 capital B of the OGLS Act 1962 by the additional Tahsildar is without authority and without jurisdiction.
In this type of cases, if fraud was committed, it was detected at a later stage. So that is why perhaps in some other case, it was a direction that you reopen everything. And that is how it has been reopened. And
if your lordship wants, I have also quoted the citation, my lord, in my writ petition. That was a case of Hadusau and Saulsau. That was way back in the year 95 and 96. An order was passed by this honorable court that in respect of all lease cases in Bhubaneswar Tahsil, the inquiry was to be conducted by the not below the rank of Secretary of the Revenue Department. And citing those two judges, in that case also, my lord, it was dealt with in my case. Because in that 7A proceedings, if your lordship sees, I'll take your lordships to that.
You are challenging which order?
My Annex 6, page 42.
Yes.
My main ground of challenge is, my lord, in an earlier proceeding,
notice has been issued.
Yes, my lord. My grievance is without jurisdiction.
Why are you challenging this notice? Whatever you want to say, say before the authority.
My lord, the very initiation is no without authority and without jurisdiction, my lord. You can take those please here. My lord, if the proceeding is without authority and without jurisdiction, and there is a
You filed your anything before objection before that.
my lord, may kindly bear with.
Yes.
My case is, my lord, in an earlier proceeding initiated under section 7 capital A of the OGLS Act, the ADM, who is the revisional authority under that,
a huge fraud was brought to the notice of this court, and because most of the officers are handing gloves with different persons, and valuable lands have been the government has been given in this way. So that is the reason why all this proceeding.
my case is not that, my lord. My case does not fall under that category.
So when notice,
because that is a finding, my entire case is, my lord, in an earlier proceeding drawn under section 7A of the OGLS Act, the ADM, who is the revisional authority under the Act, he has given a finding concerning the same case land. He has given a finding that since the lease has been granted under approved lease principles 1961,
be very clearly says that no order can be passed without giving a person reasonable opportunity.
Yes, my lord. That is
in compliance with that proviso, they have issued the notice to you. So whatever you want to say before the authority. The authority against you.
Again, my entire case is, your lordship may kindly come to page 29.
Yes.
What is my entire grievance is, my lord.
Before the authority will see that.
Then your lordship may kindly observe. Your lordship may kindly direct the additional tahsildar that let him decide as a preliminary issue whether the proceeding is maintainable before him.
Have you filed a petition for
no, my lords, no.
File it. Because you should say that unless you file it and unless
if the proceeding,
what you will say in affidavit in your objection, we do not know. How can we say that first you decide?
There is already a finding to that effect.
Yes.
There is already a finding to that effect.
File this petition.
You take the PA, and in case it does not act in accordance with the statute, you are always free to come.
The proceeding is without jurisdiction, that is no point, and there is already a finding to that effect, my lord.
Technically, 3B, section 3B submit indicates that no order is to be passed without giving the person concerned reasonable opportunity of being heard in the matter. In pursuance of such proviso, notice has been issued. Admittedly, the petitioner has not submitted his reply before the authority. In view of the fact that the time stipulated in the notice has already expired, and the petitioner has filed this petition, we give the liberty to the petitioner to file the objection before the additional tahsildar, that is opposite party number 3, within a period of 2 weeks from today, and along with the copy of the order and the copy of the writ petition, the same shall be considered by the additional tahsildar in accordance with law. And if the additional tahsildar puts it proper personal hearing to the petitioner, the same can be provided to the petitioner. It is made clear that we have not expressed any opinion on the same. The decision should be taken within a period of 3 months from the date of production of the copy of the order along with the objection, and the same shall be communicated to the petitioner within a period of 2 weeks from the taking of the decision. Accordingly, the writ petition is disposed of.
May I pray one thing, my lords?
Yeah.
My lord, since there is a finding arrived at by the revisional authority, lordship may kindly direct the additional tahsildar to decide it as a preliminary issue.
Definitely, you can take it under what authority has again issued the notice. That has to be
dismiss कर देबे, list cancel कर देबे, फिर कॉले
next
oblige.
Item number 58. May it please your lordship, I am appearing on behalf of my learned senior, Suma Patnaik. We have filed an LR application that finds its place in flag X. It is for the substitution of the petitioner number 1, Nimay Charan Pradhan, and petition number 3, Shri Bhuban Mahanto.
Order date 5599 is under challenge today.
Death certificate देगा, substitution का problem.
ଏବେ step ନାହିଁ ବୋଲି କହିଥିଲେ ଦେଲେ ନାହିଁ ତ 12/4 ରୁ ଦେଇନାହାନ୍ତି ଦେବେ
This IA who are the opposite party in this writ petition, state of Orissa. So any objection to this? No. All right.
Yes.
IA number so on so with an application for substitution. It is stated in the interim application that petitioner number 1 and 3
Yes, my lord.
are date, and therefore the legal heirs are, as per this schedule, are to be substituted. The land council for the state has received the copy of the interim application and has no objection to the same. Considering the amendments made in the interim application and hearing the land council for the respective parties, they are made in the interim application, allowed the so and so are to be substituted in place of deceased person number 1, and so and so as per this to be substituted in so on. The consolidated cost title the writ petition is to be filed within a week, giving copy to the land council for the state. Yes.
Obliged, my lord. Item 59.
My lord, this is limitation fixing, my lord. Delay has been calculated 74 days by the office, my lord. But this is wrong, my lord. Actually, in fact, there is no delay. I have mentioned, if your lordship go through paragraph 2 of my limitation section 5 limitation, my lord. Yes. I have mentioned read petition dismissed on 26/4/2021. On 3/5/7 days after, my lord, I filed an application to recall that order, my lord. That I have filed interim application which was dismissed on 11/8/2021, and thereafter, after 2 days, I have filed the request. Actually, yeah, this period has been waived out by the office, my lord.
So whether it would be from the date of judgment in the main case or from the date of the judgment in the interim application?
From the date of interim application.
How can you substantiate?
My lord, if the interim application, I cannot file that.
The judgment was pronounced.
Yes, my
lord. Period starts from the date of judgment. Suppose in case you file any application for modification, modification is dismissed. Then according to you, it should be counted from the date of disposal of the interim application, not from the date of judgment. That's petition. So the authority.
I'll try next evening. I'll try
of this matter next week. Wait for by land council. Yes.
I am appearing for opposite number 5 to 8, my lord.
Land council for the opposite party number 5 is present. Yes.
5 to 8 or 5?
5 to 8.
5 to 8 is yes.
My lord, right, I beg to say that the appeal itself is not maintainable in view of the full court judgment.
This SR is stating that it is to be counted from a different date. Let him satisfy us. Then yes.
Item 60.
May it please your lordship. This is the application is filed challenging the order of Central Administrative Tribunal. But the grievance before the Central Administrative Tribunal was that as per the pension, railway service pension regulations, before 2 years of retirement, they have to scrutinize all the records and any recovery, any service particulars, and they have to settle the retirement benefits within the 2 years, giving different stages. They are given from Rule 78 to 91. And finally, after filing all the procedure is followed, settlement is, the entitlement is decided, then they will issue provisional pension. Accordingly, on the date of retirement, I have retired on 31/1/2012. Now I am 72 years old, and thereafter I received my pension till June 2015. Thereafter, all of a sudden, without intimation, without notice, they reduced my pay and reduced the pension from 11,230 to 7,890.
On what ground?
They have not intimated anything. That is admitted fact. There is no notice. They admitted, but they found after retirement in 2015, 3 years after, they found there is some mistake in fixing the pay scale. So they reduced it. And I have challenged not only that, they have not paid my gratuity and other retirement benefits. The one tribunal passed the order to refund the amount. Only in respect of the what they have done, reduced the pay and reduced the pension, started recovery without intimation to me. So I have filed an application under Right to Information Act. In December 2016, they have intimated that because of these deficiencies, they have reduced the pay and pension.
Now that calculation is correct.
So no notice.
No, RCI, when you received it, did you find the calculation they have given, reducing the pay, is correct?
No, that is not correct. That's why they approached the tribunal. Tribunal accepted that position and directed refund the amount without interest and other retirement benefits. And I have cited this in your lordship kindly see. He has noted down all the things para page 17.
Para 17.
Para 17.
No. There is only.
Page 21, your lordship kindly see. Page 20, running page 21. Your lordship got it.
21 para 17.
Fourth line from top.
Para 79. Para 5.
Para 5. 21 is the para 5 touch.
Above para 5.
All right.
I have given that pension regulations. Where 2 years prior to the retirement, they have to proceed and decide and find So after 4 years, when I was getting the pension, they reduced my pay and reduced my pension, started recovery, and that also not informed. My pension is to be deposited in the bank. And after knowing that, I have asked him on Right to Information Act, they informed the things that is Annex 3. Before the tribunal, I have challenged it. Now, the AC already appeared, this is the only question. All the points I have taken, and I have also cited decision 52 Supreme Court, 78 Supreme Court. Once, they have issued an order, they cannot explain by way of counter that what was in their mind, why they have come to that conclusion. This is exactly that case, This is the question of law, Millard. I am 72 years. ASG already appeared. Millard, I will give the required number of the writ applications. Millard, I will only cite those decisions.
It is, we are just, this order has come for that a particular defect has not been removed. So, just remove that defect, we can take up.
Kindly see. That is not visible copy, that is already I verified, Millard, very clearly visible. That may be ignored.
Just a minute. 11.
I have seen, Millard.
Page number 29, 32 and 35. We
Need copy of things 29, 235.
29 देखिए कौन है?
29, 32, 35.
29, अच्छा, ठीक है. 32.
We will take 29, 32 and 35.
35.
I verified that really visible.
Okay. The defect is not important. The defect number 11 as for the SR fancy. Wait. The you have already entered appearance.
Yes, ma'am.
So you accept notice or we take up this matter since you already under challenge. Issue notice on the question of admission indicating therein that the matter is disposed of at the stage of admission. Please give your
Only Millard may interrupt Millard. Only question of law. I will place both things, Millard, if your lordship satisfies.
It's all right. The opportunity is to be given to file the counter.
Why, Millard? I am 72 years, Millard.
All right, we'll take up this matter immediately after this Puja ensuing Puja vacation. Counter affidavit, if any, be filed in the meantime. Now, look at the opposite parties. Yes.
Item 61.
Yes, Mr. Samantroy. Modification is disposed of this. So, please admit that service account order. Representation data annexure 3 and based on the basis of the answer submitted, then why information related to the account. Modify the order dated so by replacing annexure 4 in place of annexure 3 in the second line. Wait of 4 or submitted
In place of decision on annexure 4 instead of 3.
Okay. All right. IN number so and so. There is an application for modification of the order dated so and so. By replacing annexure 4 in place of annexure 3 appearing in the second line as well as 21st line of paragraph number 4. Hearing the land council for the state. The prayer made in this one so is allowed in so place in place of so it is to be read as annexure 4. Yes. I have according to this coding.